Yes.
Lordship, I would like to mention item number 4.
Hmm.
Lordship, may kindly take up this matter the next week.
Next week.
Lordship. Oblige, your Lordship.
Please, Your Lordship.
Hmm.
Lordship, this is a leave petition, my lord.
Hmm.
My lord, before the learned single judge, the writ petitioner had approached. It was a tender matter, my lord. But the tender was for supply of medicines to Anganwadi Center for 2 years, 2021 and 22-23. The tender was floated in 23 after the years have passed. But in any case, my lord, we were also the bidders. One of the bidder, he had approached this honorable court because there was a direction by the tender evaluation committee for retender. But before that, the earnest money had been withdrawn by all the bidders, including the writ petitioner as well as the present applicant. That fact was suppressed before the learned single judge, and the writ petition was filed.
You ought to have filed a review.
We ought to have, my
But
lord.
now already it is March 23, it will be over.
My lord,
He might have supplied in the meantime. Now
No.
we are at the leave stage.
my lord, not 23, my lord. 21-22 and 22-23. The years are already over.
Over. So what
My lord-
anything survives?
My lord, the financial bid has not yet been opened. Till date, my lord. That is my instruction.
Suppose we give leave to you also. It is a case of review. You say that this is
My-
the situation,
my
have a
lord-
review.
My lord, the single judge is not there now. So it will again go to the Honorable the Chief Justice.
Whatsoever.
My
Nowadays the review can be hard.
By
Anyway, we are issuing a notice here.
my lord.
Notice. Nothing more than that.
Yes, ma'am.
Friends who accepts notice on behalf of respondent number
1, 2, 5 or 2 to 5.
225.
2 to 5.
My lord.
And 2 to 5. No, any other? Any?
One is private response.
What is the writ petitioner?
One, my lord.
1.
1, 2 to 5. One by registered post as well as usual process.
My lord, returnable. Returnable, my lord.
Returnable for it as usual.
Deeply obliged.
Because you will have to serve and count, have
Yes,
a
sir.
return. Even to presume, we will have to have 4 for it.
My lord. Or my lord, we can be permitted to serve by dusty if it's on an earlier
Okay.
date.
In addition, the petitioner is permitted to file dusty service. Give a date after 4 weeks.
My lord, before 4 weeks, my lord.
You are so much delayed. After this leave is granted, there is delay also, I think.
Condonation, 42 days.
Huh?
Because we were not aware, my lord.
So then delay, let them come for
My
4
lord.
weeks.
Deeply obliged.
Give a date, specific date after 4 weeks. Dusty.
My lord. Deeply.
67 days.
67.
Notice. 4 weeks.
All right.
Item number? This is 2. This is 2. 2, this is 2. 2 is over. None appears for a petitioner on call. The office note dated 15/11/2023 reflects that service report in respect of the respondent numbers 3 and 4 are still await for further 4 weeks and list thereafter. Mr. Counsel, difficult today. A criminal appeal, suppose we acquit her. We'll have to pass the judgment today or tomorrow. Tomorrow it will not be possible. We are not having division bench.
My lord, my only concern, my lord, here is a case, my lord, accused person. my lord.
We understand your concern. Suppose we hear you, we make it CAV. From tomorrow, this bench is not available.
No,
It will be injustice to your client. Suppose we decide that we'll acquit you. then again injustice to you, for to us or to our conscience. This is the difficulty.
If my lord consider my bail, my lord, by bail, my lord, who I am pressing for bail, my
Considering the bail and considering the appeal in on merit is almost same in case of a appeal, because we cannot have only on the how many years you are convicted for how many
life, my lord,
huh?
life, my lord.
Life. How many years you are inside?
My lord, before my lord trial start, I 4 years,
No, no,
more than 4 years,
4
my lord.
years now. Till
And-
now,
Till now, more than 2 years, my lord. And in between, my lord, during the trial, my lord, I was on bail for 10 years, my lord, more than 10 years, my lord. That whole those years, my lord, I did not violate any bail condition, my
I
lord.
understand, but in a appeal, only non-violation of condition is not a ground. Because already you are convicted and sentenced. Now, only consideration you can make in a prima facie, you will have to have a satisfaction that there is a chance of acquittal.
My lord.
That is the ground of bail. And to have that prima facie satisfaction, we will have to go to the entire record and evidence.
Truly, my lord,
And
truly,
there are certain points which are, if you go for bail, for your for final disposal, it is a different thing. If we go for bail, certain facts are admitted
admit, my lord.
that you started cutting people, and injured witness says that you did it. Okay. Only thing is that according to it, there is no eyewitness to the date.
Yes, truly,
Is that it?
my lord.
So to the date. Except that, so whether that is a responsibility is also onus shifts upon you when already it is established that you are the person who committed that things on that particular place or period
My lord.
or time. Now that being the position, what is you have no explanation. So if we consider all this, then we cannot give you a bail. That's why we thought that we'll decide this method. For deciding matter, we can go to the other aspects of the matter, as you will urge that there is no eyewitness, there is an independent eyewitness who is required for the date, though other part is proved by the witnesses, two different incidents. These are the things, but to decide it will not be possible today. And above all, we are having independent single benches today. I am having 38 or 40 matters, and you are also having more than that, 20.
In the, I'll pray for my lord, fix that, my lord. Next week, my lord.
When?
Next week, my lord.
Next week. Okay, he's here next week.
Okay. Fix that, my lord.
Give a date.
Okay, my lord, next week, my lord. Next week, my lord.
Next time.
Hola.
I would definitely see why you do this. This is what okay, it is also after. Huh? Yes, one time.
Yes,
Who time? Who wants time? Tell us.
us,
Looking at you were supposed to take time, but looking at her face, you thought that better let her take the time.
Lordship, both are willing to take time. So next
Both.
day.
As agreed to participate, what? Please, when?
After 2 weeks, Lordship.
After 2 weeks.
I'm like.
Your orders. Foregone conclusion.
Conclusion that
Foregone conclusion. These are dismissed. Some corrections are there, we'll correct it.
Correct.
Get it by.
My lord,
Yes,
I may be allowed to move one unlisted matter. It's eviction matter, my lord.
unlisted.
Yes, my lord.
What happened?
My lord, they are going to, they are proposed to evict, my lord, tomorrow, my lord. There's a, the order is of such a ambiguous, my lord. It will, while carrying out eviction, it will bound to affect my property, my lord. Although it is appellate authority says that the boundary, beyond the boundary will not be evicted. But he upheld the decision of the state officer, wherein the state officer said that my property will be evicted, although it is lying not within the boundary, my lord.
So according to you, the appellate authority says that your property cannot be evicted.
My lord. My lord.
Beyond the boundary of the
Yes,
other
yes.
person.
But my
Okay, listen. But subject to, you bring it before we rise.
my lord.
When the order is passed by the.
My lord,
deputy-
it was passed on 9th November, but the order was not circulated on the WhatsApp Pro we got lately, my lord.
And what
Yeah.
is the date fix?
It is from 7 days from the order, my lord.
7 days from the order.
My lord.
7 days will be over, already over.
My lord, 17, it is proposed from reliable source come to know that they may evict on tomorrow, my lord.
All-
That's
All reliable sources. Have you disclosed your reliable source? We'll see that in the affidavit.
May it please your lordship.
Yes.
So, lordship, we have a joint prayer for item number 8, 9 and 10.
Ten.
Okay.
In that matter, I am filing a reply. She is
Will-
also filing a reply.
Reply, my
Can-
lord.
Can it be taken up on 19th of January?
19th of
Readings will
January.
be completed to come for
Ah.
hearing, my lord.
Mr. Senapati, learned counsel for the
Respondent number 4 and 5.
respondent number 5, as well as MS Sharma,
And Google.
N Gogoi, learned counsel for the
Petitioners.
petitioners. 6 time to file additional pleading. Full stop. Prayer is allowed. List this matter on
19th of January.
19th of January.
2024.
24.
2024.
High
Much
Lordship.
obliged.
Lordship, I would like to mention item number 13.
1-3.
Yes, your lordship. This may also be listed on 19 for the petition.
Why
I've
this
taken
matter
the
is mentioned? Who is the other side?
the others. It is
Huh?
not mentioned, my lord. 13, lordship.
13.
13,
Okay,
ma'am.
okay, okay.
It,
okay.
it may be fixed on 19, same date, my lord.
Which date?
On 19th January 20. Lordship,
Okay, as agreed to by the London Council for the parties, list it on 19th.
highly obliged. Lordship.
Appeals, my lord.
Yes.
My lord, one tender matter is being filed this morning, so this may be taken up today at unlisted, my lord.
What?
One tender matter is being filed this morning, my lord. So this may be taken up as a unlisted today, man. So,
What is the grievance?
my lord, grievances is that, my lord, we have participated in the
Tender.
NIT process.
Huh.
And now the respondent has, my lord, approved to the other private respondent, and thereby they have already, my lord, opened the financial bid also.
Hmm.
So in the meantime, my lord, we come to know
Your
from
bid
the,
has been rejected.
my lord, my case has been
Technical bid.
in
Why?
the technical bid, which should not have been, my lord.
Why it is rejected? What is the
My,
ground?
my lord, only they have overlooked I am ready to, my lord, disclose at the time of hearing, my lord. They have only overlooked that my documents were not fulfilled. Despite that, the certain documents were there, my lord. So, my lord, we are anticipating,
Tomorrow.
my lord, since the certain
When is the
others-
order passed?
13 of this month,
When it was rejected, your technical bill?
my lord, 30, my lord, by,
When your technical bill is rejected?
my lord, it is shown as 10, but
No,
despite
just- Can you answer my question? When the technical,
Ma-
bill, then we'll go to the result.
10, my lord,
Yes, when it was rejected?
my lord, 10 November.
10th November.
Yes, that week,
We can have it tomorrow also.
my lord,
We can have it tomorrow.
my lord.
Tomorrow,
So, my lord, so,
tomorrow, we give the date tomorrow.
May it please, your lordship.
Yes.
Lordship, there was a matter which, in which the date given was for tomorrow, my lord.
Hmm.
But then it was not reflected in the order. So I'm told by the registry it may not get listed tomorrow. Could it be taken up tomorrow, my lord? The date given was tomorrow's fine.
Yes, date given was?
Tomorrow's fine.
Okay, but in the order it is.
It was not reflected. It was left out in
Which
inadvertently.
item?
My lord,
Yesterday.
no, not yesterday. My lord, WPC 193 of 20.
What was this issue?
My lord, it was land acquisition, my lord, for the Holongi Airport, my lord.
Hmm.
My lord, there was no award passed. Without passing an award, so we cannot go in for a reference as well, my lord.
Okay.
So we need the award, my lord. There is no award in existence to my instruction. Come on.
Okay.
For tomorrow, my lord. Deep.
May I please, your lordship, I beg to mention item number 7, your lordship.
7.
Yes, your lordship. This
Yes.
is contempt petition. The grievances of the petitioner are under consideration, your lordship.
Okay.
So this matter may be listed after 3 weeks, your lordship.
Yes, are you appearing, Mr. Pogasta? So what do you say? He says that he wanted an adjournment. Mr. A.K. Singh, learned counsel for the petitioner, submits that the case of the matter may be adjourned as the case of the petitioner in terms of the order
In terms of
Dated.
order,
dated.
lordship,
Okay, Rajas write it on the prayer of the learned counsel for the petitioner, Mr. A.K. Singh. Matter stands adjourned and be listed
after 3 weeks.
after 3 weeks.
Let the matter be considered. In the meantime, I'll inform him early. And the date will be.
Let him have the, what is the problem? Let him have the privilege of having a date, 21st of December 2023. December. Now, don't write for the praise for according.
No, my lord. My lord, I beg to mention item number 11, my lord.
Item number 11.
Yes, my lord. This matter may be adjourned for today, my lord. And matter may be fixed on 23 of this month, my lord.
What is the matter about?
Matter is about, my lord, serviceman.
All equal.
Yes, my lord.
You are for respondents of petitioner?
No, I am for the petitioner, my lord.
Petitioner, okay.
Yes, my lord.
On the prayer of the learned counsel for the petitioner, matter stands adjourned for.
Matter may be fixed on, my lord, 23 of this month, my
23, why? What is the precious date on 23rd? Why can't you do it today?
No, leading counsel is having a personal
Okay.
difficulty.
23rd.
Okay, much obliged.
Okay.
marvelous, man.
Yes.
Well, this is already cover a matter in the writ petition number 11 of 2020, whereby my lord, the direction was made from this honorable court to dispose of our representation within the 20 days. My lord, may kindly come to the page number
Page
29, operating person, my lord. It is start from 28 and 29.
Now, how a second repetition is maintainable?
My lord, on the ground, that my lord, since my lord, this was supposed to be disposed by the respondent
You
authority.
are waiting for 3 years.
My lord. My lord, the respondent has showed the time one after another we take to consider.
Heard Mr. Spencer, learned counsel for the petitioner.
Otherwise, my lord, I have only the limited prayer, my lord. just the extension of the time frame.
2020, you were sent to somewhere else. There was a direction for consideration.
My lord,
Direction for consideration. You have
Consideration.
not filed any contempt.
my lord, exactly, my lord.
Now,
That could
no
have done.
contempt has been filed. Last 3 years, this order is not been.
I admit, my lord.
Now, second issue is, what is your right to be there?
Yes, yes, my lord.
Since
The present application is filed assailing inaction on the part of the respondent authorities is not complying with order dated 28/5/2020 passed in WPC 111/AP/2022. Full stop. The Learned Standing Council, Mr. Jamu, raises a question of maintainability of the present writ petition on the ground that this petition is barred inasmuch as the same issue cannot be determined in subsequent writ petitions, which has already been decided in the earlier writ petition, that is WPC 111/AP 2020. Full stop.
Apart from that, my lord, page number 19.
Apart from,
Appointment is also temporary, my lord.
it is further contention of Mr. Jamu that petitioner is not having any right to
Page number 19, my lord.
right to assail the impugn order dated 28th of January 2020. Order not impugn, order dated 28th of January 2020. In as much as the petitioner is not having any vested right to continue to work as your Tadar Tadung,
my lord, son of us.
as BRCC, CRCC. Okay?
Right.
BRCC, CRCC. This matter needs further consideration. Accordingly, issue a notice returnable after 4 weeks. So accepts notice on behalf of all the respondents. As okay, it is made clear that the issue of maintainability is kept open. And the respondent department may file affidavit in this regard.
May I
This
please-
matter is listed. In 11, okay.
My lord, this is a 2019 matter, my lord.
Yes, tell us what is this. Yes, tell us what is this. Allotment letter issued to him.
Oh, yes.
Under what provision? Tell us. I just want to understand. Here I have seen only case of allotment and cancellation.
Yeah.
Huh? What is, under what provision these allotments are made?
My lord, there is an application permit, my lord, issued by the deputy commissioner, my lord, where there are certain terms and conditions and declaration also, my lord.
Under what provision of law such allotments are made?
Now under an act, man.
Hmm.
Now under an, earlier just on application, my lord, they used it.
Anybody and anybody can.
Yes.
But tell us another thing. I have seen in many cases that these are community lands. Land acquisition will be given to the community. Now, how if the lands are of all lands are community lands?
Not all. Depends from tribe to tribe also. Different tribes have different type of land also.
What is the land law as such here?
There's no land law, so that is the difficult.
You
The
should
land
initiate
settlement
a
act
proceeding.
also says those
You
lands.
see, I have seen many problems because you cannot determine many cases like you do in a regular manner.
Yes.
Suppose here people comes and says that who the community leader will distribute. And somewhere we have seen now that has led to a commission. What core committee will have 10%. So now it is leading to that extent. The community leader will get a cut from the land acquisition. Because
Yes, that's happening.
is facilitated.
Yes, it's happening.
So therefore a land law is definitely
Land law is
required.
required. The 2000 Land Settlement Act does not take care of this. It's very
How
vague.
the right will vest? Suppose it's here is a community to community, that is also fine, but it should be codified.
Yes, it should be, it should be.
Here
first of-
allotment is of 28th of June 2019. What happened thereafter?
This is, my lord, this is a notified government land, my lord. So,
No, that understand that notified government land can be allotted in this way. So you must have some authority of law. I'm not saying about this, your case only. Everywhere, in some other cases, he appears, there is also allotment.
Yes.
And there was cancellation. There must be procedure of allotment as such procedure of cancelment. What is the cancellation procedure?
you can say the deputy commissioner can, my lord.
Under what authority?
There's
You,
no-
just for my knowledge.
Yes.
For cancellation, there is no law.
No rule. So principles
the
of natural
under the
justice will follow.
Land Settlement Act 2000, my lord, this allotments can be done. The rules from there are 2014 rule. Allotment can be done by the deputy commissioner. Now for cancellation, there is no provision.
No provision. Suppose assume that the authority who can give it, he can withdraw it also. That principle of law is even if applied, then there must be some proceedings. Why you want to cancel? Under what circumstances you have given? There may be fraud. There may be misrepresentation. He may not be entitled. All this ground can be there, but we'll have to put him a notice that we want to cancel it. These are the reasons.
As far as this case is concerned, my lord, this is a totally disputed question of facts in this petition. He claims this is his land. We say you have transferred it to my late husband. That is how this has now been transferred to me. All disputed questions of facts. This is
Now,
a case for the civil court.
how, then where is the cancellation?
There's no
No,
cancellation, my lord.
lordship, the discrepancy in regards to land law is always
How
there.
can read court decision? Why don't you file a declaration that on the
Has to-
basis of this allotment letter,
Hmm.
I have right title interest over the suit land or the property? Then get this declaration, because now the complexities I am seeing, there is no other way but to go to the civil courts. You may say customary laws and all, but the complicated, earlier it was fine.
But
It's simple society. Now it is going to so complicated, even the community members are taking commission for distributing land compensation, compensation to its own community members. And on record and approved by deputy commissioner. The 10% is yours. Core committee, it's called core committee.
my lord, in the instant case, my lord, the same plot of land, my lord, which
Now what is his stand? What is his stand? Same land is allotted to him, his
Yes,
client.
up to
Now what
90
is his stand?
My stand is, my lord,
Hmm.
by way of a gift in way back in 2008, the land was transferred by him to my late husband.
According to you.
Yes,
And so this is your
there's
case.
an agreement also. That is why I'm saying the disputed questions of.
Okay, so and what is the stand of
That is the
the,
stand of the government also.
then how can we decide whether gift it was given or not?
Yes.
no, my lord.
We'll have to have a
That is
box
the-
here.
Even if in that case, my lord, this would have been a case of transfer of land, my lord.
Hmm.
No transfer has taken place. Even if it is assumed, my lord, that this was gifted to the respondent number 11.
Now we
when
have
it
to say
was-
that gift is null and void.
When, my lord, no gift deed was taken place, my lord.
No, we'll have to come to a conclusion that there is no gift deed taken place. For
Yes,
that, we'll have to examine the witnesses that there is no gift deed is taken place.
Yes, my lord. That is why, my lord,
How
record was.
can we do
That
that?
is what exactly he's saying in the reply. Not exactly. He says that this gift deed is not, he does not exactly say this is a fake gift deed. But he also says that this was not done, but he also says, assuming it is there, then also the person before whom it was executed, he was not posted at Alo at that point of time. We file an RTI
So you
application.
see what are mistake you are committing. When this affidavit was filed? When this affidavit was filed?
Well, the first affidavit was
When you bought the gift deed for the first time on record?
Record was called for, my lord.
April 2022.
April 2022. March, April, 2022, 23, 24, 25. After April 25, you will even lose the cause of action to file a civil suit for cancellation of the gift deed. Because it is brought to the notice by a gift deed, and for cancellation, you will have to have a limitation period of 3 years. And after 3 years, this will be get dismissed, and he will come. So you had a knowledge on such and such that your suit is barred by limitation.
There's no way,
No,
my
my
lord,
lord.
this court can decide
In
this.
the matter of land allotment and cancellation, my lord, DC is the competent authority. That is why we file a complaint before him, which has not been considered and disposed of as on today, my lord. Because, my lord,
Suppose in view of the stand that he has taken, suppose in a view of a stand that he has got it by virtue of a gift deed. If we proceed further, or the DC proceeds further, DC will have to come to a conclusion either rejecting his contention. Suppose you remand back the matter to the deputy commissioner. We will have to ask the deputy commissioner to hear not only you, him also. Okay? Moment we ask you to him, he will take the same stand as he has taken. Now deputy commissioner is to determine whether the gift deed he is relying on is a genuine or a fake one.
yes,
Is not it?
yes,
Can a deputy commissioner do that? So if we remand this matter back to the deputy commissioner also, he is also not having authority to do that,
And he has.
except filing a civil suit or going to the village court as per your customary law. You have no other option.
no, my lord, DC being the allotting authority, my lord, this court has to see whether the deputy commissioner committed some illegality, my lord, in allotting this land.
Suppose
Yes.
allotting the land, suppose deputy commissioner stand is that we have on the basis of the gift deed, we have allotted the plot of land, isn't it?
Yes, yes.
That is just then. So we'll have to decide whether deputy commissioner could do is.
My lord,
We can give you a
Respondent number
liberty to approach the civil court with a provision that he will be at liberty to seek a declaration that deputy commissioner's allotment in his favor is can be also challenged, because a declaration can be
Yes.
sought for that this is null and void.
I am still paying the land revenue to the.
Yes. Argu.
So, my lord, in any case, my lord, this plot of land in question was allotted to me way back in 2000, my lord.
Okay.
Then,
Where is that?
here is- this is, my lord,
Your name is
Domar Sharma, page 22, my lord, onwards,
Page.
page 22.
What is that 19? Page 19, page 39? Annexure 19.
This is the land or allotment order.
In your favor. Page 19,
19, my lord.
90. No, his allotment.
Oh, my.
Page 22, my lord, page 22.
Page
Page 22 onwards, page 22 to 25, my lord.
It was allotted in whose name?
Domar Sharma, the petitioner's name, my lord.
Where is that?
Page 22 to 25, my lord.
Page 22.
Yes.
You have a very good case for seeking a declaration. If you can prove that it has been allotted in your name, you say that my husband was not having any right to gift. Matter ends there. We cannot decide that. Anyway, if you are proceeding, but you are taking a risk that if we decide, then you might have a problem in the civil suit. You are not understanding that. Domar Sara.
Yes, ma'am.
Who is Domar Sara?
The petitioner, ma'am.
You are gents or ladies? Male or female?
Male, ma'am.
Male. Okay.
So after my allotment, my lord, in the year 2000, I was staying there in a kacha house, my lord, since 2016. But for convenience of my school going children, my lord, I temporarily shifted to another place, my lord, near the school, my lord. So in the year 2019, last part of 2019, my lord, when I tried to make some concrete, my lord, house there, my lord, a permanent structure, my lord, I found that the same plot of land measuring 350 square meter, for which my lord, still I am paying the revenue, my lord, has been allotted to the respondent number 11, my lord. And the only contention, my lord, of the respondent number 11 is that this plot has been transferred by the petitioner to her, whereas, my lord, there is no record as such, my lord. Even if it is assumed that gift deed is a valid one, my lord, this was taken between the petitioner and the husband of the respondent number 11, my lord. And if at all this is a
According to him, who transferred this land to whom?
the petitioner to her, my lord, to the respondent number 11.
Uh-huh.
My husband has died. So,
So it was transferred to your late husband by him.
But no transfer record, my lord. Only claiming, my lord.
Any gift deed?
yes,
Where is that?
my affidavit, my lord. Respondent number 11, page
Respondent
20.
number, page
20.
And my lord, original gift deed was called from the deputy commissioner, my lord, and it is found that
How
no.
can read code verify
But
all
there's
these?
absolutely no way, my lord.
Then, my lord,
We are not binding by such kind of orders.
yes, my lord, then I may be kindly allowed only to convince that, my lord, this allotment is illegal, my lord. Only few lines, my lord. Because, my lord, in any case, I was allotted the plot of land in the 2000, my lord. And since 2000, till that, my lord, I have been regularly paying the land revenue, my lord. And the only contention, my lord, by the respondent 11 is that this has been transferred to her by the petitioner, which is not true. They have filed a false affidavit, my lord. In the, my lord, allotment application itself, my lord.
All this forgery and all, we cannot decide in the writ petition. You are not understanding. You might have a very good case. You might have a very good case. You will challenge that there is no gift deed. You will call the deputy commissioner if there is no gift deed. Then matter ends there. You have a limitation of 3 years to file a suit and you are fighting in the writ court. Unfortunate.
My lord,
Yes, I was sincere arguments.
my lord, in the allotment application, my lord, application format, they have even stated that this plot of land was occupied by the respondent number 11 in the 1996. And as per her birth record, my lord, in the year 1996, she was only 11 years old. How can a 11 years old occupy plot of land? Thereafter, it was regularized, my lord. And they have made a declaration that if anything is found adverse and misled by him, then it will be liable to be cancelled. Give the. On the one hand, my lord, she is claiming that he has acquired the land.
You have a very good case for a decree suit. I'm telling you, if you properly do it.
Yeah.
You bring all this on the suit, prove it, call the record. Can we decide whether he was born in 1996 or... Anyway, proceed.
So, my lord, there is a clause, my lord, in the application format itself, which is at page 52, my lord.
That if any wrong declaration is made, its allotment is liable to be cancellation. We'll have to make a wrong declaration. What is the wrong declaration? That she declared he is born in so and so, so and so. So at the 11 years, all these findings will have to come. Isn't it? In a writ proceeding. And these findings can be concluded in a, since you are arguing, you will have to conclude all this. This may go in your favor, this may go against him, or in his favor. Now that will be binding upon all civil courts. Isn't it? First of all. Second, can we determine all these disputed questions of fact in a writ proceeding? That is another answer. Question.
My lord, in that case, my lord,
He is giving
My lord,
good advice to you.
yes.
Good advice to you.
m-
What is the advice?
my lord, I
Take
need
an
to
adjournment.
further instruction, my lord.
You need further instruction. That is what we are indicating. Last day, I do not want to this. This is not a case. Better you advise your client, take your instruction from your client.
Yes, ma'am.
No read court can issue a direction as sought for by you in view of the dispute raised by the respondent as well as the state respondent. At the same time, we also cannot uphold their contention
Yes.
that there is a
exactly.
gift deed. We also
Exactly.
cannot hold that there is a
Yes,
gift deed.
Yes, yes.
We cannot
Exactly.
say that there is a genuine gift deed. Moment we say there is a genuine gift deed, your all rights are finished.
Yes.
And moment we say, and we cannot say that that gift deed is not valid.
Yes.
That determination is required to be made in a civil suit.
Yes, ma'am.
And to file a suit for cancellation of the order of the gift deed to seek a declaration and cancellation of the gift deed. The period of its limitation of 3 years from your knowledge that fraudulently that has been executed or that is non-existent. That will over by 25. Okay. And secondly, you have all right to even seek a declaration for cancellation, declaration and cancellation of the order of allotment by the Deputy Commissioner being based on fraud. And to determine fraud, there must be specific pleading and proof. Specific pleading, not only there is a fraud, it will not do. I'm taking a class on CPC. Isn't it? There must be specific statement. There is a provision itself in the CPC and Evidence Act, which says how to fraud is to be pleaded, and you have to prove it.
Yes.
In that situation, can a read court decide without evidence that your allotment was correct, his allotment was wrong, his gift deed was wrong? To allow your reputation, you have to come first finding that this gift deed is wrong, that the application on the basis of which allotment was made was fraudulent and there was a wrong declaration, and therefore the allotment is bad, which we cannot.
Yes.
What to do?
My lord,
You
I
want
may be,
instruction?
I may be given some time, my lord, to
Nothing will not, it will improve. Nothing. We cannot take up this kind of disputed question. Learned counsel for a petitioner. That indication we are giving from the starting of your argument. Until and unless he advises you that you are not getting it. On the prayer of the learned counsel for a petitioner. Please this matter
After a week.
after a week.
Okay.
complain.
Advise your client properly. He might have a very good case. Item? How much? 12. Non-appears for a petitioner and for. Yes, why this matter is listed today?
My lord, last occasion, there's some suggestion from the my lord side. It was for because this was bill pending matter and it was observed that this record
There
did not
dispute.
interfere.
Yes.
So it
Instead
will be
of
better.
dismissing, we adjourn it. You made a mention. We
Yeah.
dismiss it today.
No, for that purpose only, I have come with the appropriate direction for the lower court as advised by the Lord. That is
No,
why.
we cannot advise. We can decide.
No, that is I took time and I decided. In fact, I thought that this is a proper thing. So the lower court,
It's specifically
lower
stated.
court will be the
The
appropriate.
learned counsel for the petitioner submits that in view of the dispute raised by the respondent authorities in their affidavit regarding the entitlement of the petitioner, the petitioner would like to withdraw the present writ petition with a liberty to approach the appropriate forum for claiming the aforesaid amount as well as compensations and interest. Full stop. As the petitioner shall have a right, as the dispute has been raised regarding entitlement of the petitioner, this court is also of the view that as the due is not admitted by the respondent authorities, this court is also of the view that a writ court cannot decide such disputed questions of fact. In that view, however, the petitioner shall be at liberty to prove his case in an appropriate forum. Accordingly, the present writ petition is closed on withdrawal with a liberty to the petitioner to approach appropriate forum for the claim of the bill against which he has allegedly executed the work. Full stop. Closure of this writ, all questions raised by the petitioner and respondent shall be open to be determined in the appropriate forum.
My lord, one small prayer is that it is the matter of 2019, so the limitation may run. It is only for the period of 3 years.
No, 19, 20, 21, 22. When the affidavit was filed? It will from the date of affidavit. Dispute is raised on the date of affidavit.
2012, 2022.
But we cannot condone the delay, the limitation in original. No?
22, Your Lordship, 2012, 2022.
You have that.
So, like,
because this is an original limitation, no court can condone this, even a writ court. Original limitation. Nobody is having authority.
No, however,
suppose it's 3 years from the date of
the date of the affidavit.
from date of denial.
Date of the denial.
We will not advise all things. From the date of denial, you claim it.
Okay, my lord, then it's okay. Otherwise, I'll be in
No, that is, we
hang
cannot.
out position. Okay, my lord.
Mr. Tara, you will have to adopt with the CPC and all procedures. Bar is lacking. Sorry to say, otherwise very sincere and hardworking bar, but you will have to look into more particularly in criminal matters. I have seen the trials. So we'll have to have some training sessions for the young lawyers. Because it's a new bar. First, second thing is that system, the adjudicatory mechanism was different altogether. Now it's transforming to a new things. So these problems will be there. Suggesting in a cross-examination, what is your defense case? I have seen that in Aizawl also. No suggestion, nothing of that sort. Now in the defense, he will take all the defense available to him, but there is no suggestion put to during the cross.
That is helped by there is an English proverb. The Lord has already segregated the chaff from the grains. Accordingly, when I also take that because I had a time.
So you have it something, it's necessary now.
I'm going to have a seminar on the.
You have it, better you have it, because ultimately cases are day by day, I have so many cases are coming up. More particularly Land Acquisition Act. Land Acquisitions Act is something different. Here notice is issued to the individuals, communities are coming saying that this is community land, then they will have a distribution formula. This will be for the community, this is for the individual. If individual, it is individual. Then this is for the committee. This is not done in
I understand.
when it's ruled by rule of law.
Right.
Yes, next.
Okay. Obliged.
Yes, Pasighat Smart City.
Yes, sir.
Yes.
I have filed an IA in this
Ah.
toilet for
So come this side.
Yeah.
You are the applicant.
for setting aside the stay order, Your Lordship.
Tell us why, what is what?
Your Lordship, I'm a Pasighat Smart City Development Corporation. I'm incorporated with the Companies Act, and I'm a PSU under the Ministry of Housing and Urban Affairs. Your Honor, Your Lordship, I've been engaged for implementing the projects, smart city projects under the Pasighat Smart City Development in Pasighat, Your Lordship. And one of the project which I was undertaking, Your Lordship, is the construction of the open gym, Your Lordship, in Pasigat. And the construction was completed. It was left only for the construction of the paving and pathway, Your Lordship. It was left only for the construction of the pathway, Your Lordship.
Construction of
Pathways.
parkways, okay.
Yes, Lordship. The gym has already been completed. During construction of the pathway, Your Lordship, the petitioner came forward and claimed that that land is belong to the petitioner, Your Lordship. Citing that prior to in previous year they have gifted some land to the government, and in lieu of that they want this particular land to them. So they have obstructed the construction, and the company with which the matter or the project was given, they have approached us, the DC, the deputy commissioner, and the deputy commissioner has passed an order stating that there's no official record in saying that the petitioner is the owner of the land. So he has directed the contractor to proceed with the work. And the petitioner has come before the Supreme Court and challenged that order. And that order has been stayed. And the works for
Where is the notice? That action is taken under which provision of law?
Lordship,
That action of the deputy commissioner regarding his eviction is taken under what provision of
Your
law?
Lordship, because they didn't prove any ownership. They only say that
No, we'll come to the ownership because later on, assuming for a moment he is not having an ownership, it is a government land. What is the procedure to evict a person from a government land?
2003 Act, Arunachal Pradesh Public Premises, Election of Unauthorized Land.
Now, who is to issue notice?
State officer.
Whether notice has been issued by the
Nothing.
state?
Your Lordship, but they are not the unauthorized or the authorized
No,
open of the
they
land.
are not. We admit for the time being that they are not the owner of the land. We are guided and controlled by certain law. According to you, this is the government land,
Your Lordship.
okay? And according to you, he is in illegal possession of a government land. Eviction question or eviction?
He came and claimed that it is his land.
He
came and claimed that it is his land, that he won that in
No,
lieu of
you said that it is not his land.
Yes.
We accept that.
Lordship.
For the time being, we accept that this land does not belong to him. This land belongs to government because there is a government project is going on.
Your Lordship.
Okay. Now you want to evict him. Isn't that it?
No, there's no eviction, Your Lordship.
No eviction.
No eviction. He is not occupied the land also. He has never occupied the land.
Okay. Then what is the stay?
Your Lordship, the stage, the project is completed. Only remaining is the construction of the pathways only. The open gym has already been constructed. Your Lordship may come to the annexure from page 150 forward. Your Lordship will kindly see. The
What
gym
is
has
the
already.
impugn order? Tell us.
The impugn order is at page 147, Your Lordship. 148 is the impugn order.
No, not impugn. That order which was impugned in the writ petition.
Yes, Your Lordship. Page 148. Second last paragraph, Your Lordship. After hearing the learned counsel of parties on being premises as far is directed that till returnable date, impugn order dated 7/2/2021, the order was passed by the DC. This was issued by Deputy Commissioner of East Central shall remain suspended. So for the past 2 years, the project has been kept on hold, Your Lordship. So, and there's
Okay, according to you, he is not in possession, but he is obstructing. So
Yes,
this is
Your
not
Lordship.
an order under the act, isn't it? Yes, Mr. Tara.
this is only the order of directing the contract to proceed with the work, Your Lordship.
This is under challenge.
Yes. And
Well,
he's claiming that he
number
is
one,
the
Milord.
occupied, authorized occupation
Two
of that.
things here.
Well,
Just answer, before going to that, two things are there. First of all, assuming for a moment that that land belongs to you. Assume that you are correct, that land belongs to you. Or that has been given in exchange in lieu of a land donated to the government for Pasigat College,
horticulture. college.
horticulture college or something.
Correct.
We take it to be correct. Is the government not within its power to acquire your land?
Can,
Huh?
can.
Can. They can acquire this land and they can proceed with the public work. Okay? Now suppose we held that you are entitled for the land and there was a land in lieu of that. You can very well be compensated in terms of money. If you can be compensated in terms of money or by way of acquisition compensation, two questions we'll have to answer for granting a stay. First, your private interest and the public interest. Your private interest is to the extent which can be compensated in terms of money. And the public interest for which a project is stalled, for which the contractor may claim escalations, may claim interest and compensations and damages. If you say that I agree to compensate in case this repetition is not allowed, and we will quantify that amount.
Yes.
What is the project worth?
Project, Your Lordship,
90.
So better,
95%.
let this complete this project
No.
and we'll keep it open
I-
so far relating to the other
no.
part of the
No,
repetition.
I'm looking for a disposal today. I'll make a brief submission, which I'm sure my lord will be convinced. See, basically, my lord, this read petition, please take your seat. This read petition has been structured on two questions of law. First, I have donated land for establishment of agricultural land. Government by means of verbal assurances that you will be given alternative plot of land. Accordingly, a similarly situated person was given land allotment.
So therefore,
I-
just a minute, therefore, we will give a direction for alternative land allotment to you. But for that, what is the benefit will you get for stopping the public project?
Here, my
You
lord,
can be given land in a different place, you can be compensated in terms of, this is your admitted position.
let us argue on the prudential theory of arguing this case, my lord. The prudential theory of argument is that if the land to a similarly situated person has been given and I have applied, my applications are pending before the deputy commissioner and you are not giving me the allotment. That is first, that is intelligible differentia. And these intelligible differentia cannot be allotted, permitted, my lord. And my lord will kindly recall that if this honorable court has to exercise power, we'll recall that Marwari versus Medicine, 1867, 1 crunch, my lord. This is a proposition of law enunciated by Lord Marshall, the Chief Justice of the Honorable Supreme Court
No,
of
comes
US.
to the
No,
law
I'm coming.
enunciated by the Supreme Court
Yes.
or in a case High
No, no.
Court regarding grant and refusal of
That
interim
is what,
order.
my lord, that-
Grant and refusal
No,
of
no.
interim order.
Well, I am just seeking an indulgence. So my lord will kindly look this case from this prudential aspect. That is
We'll
one.
look it in the
Yes,
time
one.
of when we decide
And
this matter, this is a discrimination, you allow
Number
him a
two,
land.
number two, second limb of.
We are on the.
I am
on-
answering.
On the,
I
on
am
the
an-
merit or otherwise of this application, IA.
No, let us dispose of this matter.
No, disposal is not be possible like that way
Then-
today.
Then, my lord, the second question is, whether that land was already in my possession. And my lord will kindly see that form that I have submitted is at page 18 to 20 of my read petition, my lord.
Yes.
18 to 20.
of my read petition. A small read, but the affidavit has come more than bulkier.
Yes, 18.
Page 18, this is my form, my lord. This is my form, my lord. And then this is my treasury challan at page 20, my lord. 2019. It is not a question of obstructing the land, my lord. It is a question of claiming legitimate right over the land for which
That
government
is
cannot.
what we are asking. Suppose
Yeah.
you are entitled for this land. Suppose you are owner of this land. Forget about you are applying.
Yes.
We admit that by virtue of your exchange, you have already become owner. Let me assume for that
Yeah, my
moment.
lord, for
We'll
that,
say that you are already owner.
Yeah.
Cannot the government take the land? If government can take the land, you will have to be compensated.
my lord, a
Your
while ago, my lord.
article under 300A is subject to reasonable restriction and subject to due procedure followed by law. And
Similarly,
due-
298.
Due procedure,
298, they have to follow.
due procedure is the Land Acquisition Act. They have not taken. Suppose we decide tomorrow that you are entitled, then they can even acquire this. So for the time being, we are not inclined to stall a project in case of a petitioner when it can be, even if his owner of the land can be duly compensated.
Well, I'm coming to that. Number two, why this impugn order issued by the deputy commissioner is not sustainable in law. A person assuming a single person holding two posts as a deputy commissioner, Smart City, Pasigat. Yes, as a deputy commissioner, immediately he can invoke section 12 of the 2003 Public Premises Eviction of Unauthorized Act. Under that,
No,
what-
that is not your
No,
case.
no, I'm coming, my lord. Kindly allow me to make the argument, my lord.
Yes.
Yeah. But that's why I am coming to my lord's, answering my lord's question that has fallen. Secondly, as a chairman of Pasigat Smart City Development, he do not have the power. You cannot. You do not have a power to oust me over my land. Now the question comes, under what capacity? Is it by a deputy commissioner? If it is by a deputy commissioner, yes, my lord, I'll bow down. That is what the mandate of Article 300A also says. I have a limit restrictions. In that case, I could have bowed down. Without arguing, my lord, I could have just closed down my brief and walked over. Second aspect is, if you are acting in the capacity of chairman, Pasigat Smart City Development Council, it prima facie indicates quid pro quo. That is what my lord has pointed out a while ago. In the land compensation matter, there is a core committee, and that core committee includes a lot of things, my lord. This is part of it. Coming to their affidavit, my lord, their IA. They said that 95% of the work has been completed. 95% of the work has been completed. Now the question is, larger question is, how can you interfere in my matter? You cannot be clothed with the law with impunity to question my possession of the land and my legitimate right. What legal and fundamental right of yours has been violated by this interim order? If this interim order is vacated that way, my lord, where do I go? The same person is sitting. It will cause a great prejudice to my right. Am I not entitled to that, my lord?
You are entitled. You are entitled to your right.
And first
And
aspect,
when
my lord,
you can be
my lord.
compensated.
Yeah, my lord, that compensation.
When
May-
you can
may I
be
be given-
compensated.
May I be given some time to seek instruction from my client? Because if these comes from my lord, then there is no adverse.
No, we are
Lordship, there is
otherwise-
urgency in the matter.
Lordship, you have your own time to rejoin. My lord will see what if they are agreed. Any contractual terms and conditions are violated. then they can go to civil court. Who are you? You are an stranger to my land.
No, this has been.
Chairman,
filed by-
Deputy
it has
Commissioner-
been filed by the Development Corporation, Smart City Development, not by the contractor.
Then they have no power.
No.
Under what authority they will come?
I am the implementing agency of this project, and I have the power. And your lordship, with regard to sir's submission that he is the owner of the land, your lordship has made a very important observation that he has applied, has seeking for that land. In lieu of that, he has donated some land for for some other projects.
What is the
Lordship,
donation, Mr. Mr.
your lordship, if may kindly come to
No,
page
no,
17 of
Mr.
the.
Mr. Tara, where is the land donated by you? Your statement and any particular document particulars?
My lord will kindly see.
Paragraph 4.
My lord, before that, kindly come to page 16. How the public representative have written a note.
Huh?
It is by a Minister of Education, Government of Arunachal.
What he has written?
I'll read out, my lord.
Just a minute.
Page 16. My lord, this Osin Shiram Tamuk
Just a minute, page 17.
16, my lord, 16.
Page 17, your lordship, you may kindly see the notes, your lordship, down where it's
Just
clearly
a
written.
minute, give me a moment.
You take your own time for it, don't interrupt. I have my right established, my lord. Page 21, my lord. Serial number 2 was given allotment on the same recommendation, my lord. You cannot deprive me of my right, my lord. This is the land allotment given to the similarly situated person.
When the college was established,
That 2010, my lord.
you are Zering Tamuk.
Yes.
You are Oleg Mize Tamuk.
Oleg Mize Tamuk.
So who is Zering Oze Mize? You are Oze Mize.
Yes.
Serial number 1.
Serial number 1. And serial number 2 was given land allotment.
Osi Siram Tamuk.
Yes.
And
the land, and then page 7.
where is the allotment in favor of the 2?
2, my lord, page 21. Osi Siram Tamuk, my lord.
Yes, we'll give you, you will be entitled for the land, most probably. But that will we compare that will may give you a better land somewhere else or may be compensated. But let us not stop this project public interest.
No, that-
You want
I-
you
I
want
res-
a source meeting.
Milord, I respectfully bow down what is being
Yes.
fallen, being
Yes,
falling from my
because
lord.
admittedly,
Number
your
two-
recommendation is made by the local MLA as well as the minister.
Yes, Lord.
Saying that they have donated land for this. It's Minister of Education will be a competent person when he has given the EO note.
Correct.
Because it's an agriculture, educational institute.
It is on his.
No
initiative.
problem on that. Suppose somebody has been allotted, someone is not allotted. We do not know whether hard land is required or not. Osi Siram Tamuk.
Same. Adjacent to the, adjacent to my land.
Since they are saying that they want this land for the completion of a project.
Milord, kindly
Okay.
have a look to their, this thing, where is that?
We are not having a copy of IA.
No, I am having 140, 1 144. IA is 152. They have categorically stated that para 11, my lord, will come. The page 10, my lord. That since existence of said order dated 01/21 passed by this honorable court, the construction of the said project has been put to halt and same has caused use loss of public money. The area of the said open gym in which the construction is completed, mark this. Construction has completed. For what they have come. If you are aggrieved on completion of your work, if you are not paid, then you have every right to sue the state government. That will start falling from 298 of the constitution. You are trying to take away my property, trying to encroach my property in this manner. Justice Ray in paragraph 533 of Kesavananda Bharti judgment, while dealing with this particular case, has already been dealt with. I'm sorry, my lord. I'm coming out with a lot of.
Okay. Yes, next.
Then, my lord,
they are stand.
Yes, my lord, kindly
See, they are standing in the affidavit.
Well, I'll see this.
In the writ petition.
My lord, for one more moment, my lord, that impugn order I want to demonstrate why it is patently illegal without jurisdiction.
No, we can set aside. That is the question coming into the mind of the court time and again. We can set aside this order. We can even go to that extent that yes, you are entitled for allotment. But
my lord,
can a writ court issue? No, at any cost, he should be allotted the land he is occupying.
That is not the
Can the court issue a direction that no, it cannot be acquired? If that be so, why should states, if that your right is protected, or you can be alternate, you are having alternative remedy. If they want to continue with the project, why should we stop this one? That is the simple. We did not go to the Kesavananda Bharti.
My lord, I have just taken my lord to page number 10.
Yes.
Para 11 of their the IA. They have said that work has been
So
completed.
if that it is completed, it is completed.
Completed.
I have never dispute. I said it's completed, but only left for construction of apartment and paving and
Payment,
apartment.
that is you have said it.
And gym cannot be used without apartment and pathways, Your Lordship. It's incomplete.
Photo they are using, my lord, according to the kindly see they shown.
Therefore, if they are using, there is if
Your
it is
Lordship-
vacated, no problem.
Your
for you.
Lordship may kindly
Then
come.
No problem for you.
Yes, my lord. Then, my lord, only one thing may I request.
Yes.
For that compensation aspect, if I
We
can.
are not deciding this, we'll record in the order that since your claim that is to be determined in the writ petition, that you claim that office EO note is there. So even if we decide that you are entitled for the amount entitled for the land to be allotted, or they are bound to allot you a land. In that event also, a land can be taken by the government. Therefore, that question is kept open, whether you are entitled for alternative land, for land you have purportedly gifted for the college, and if not any other land, how it your compensation, that is open.
May I kindly?
That is
given-
open.
May I
Always.
kindly give a small liberty, my lord, to speak to my client?
Yes.
Because I am the court officer, my lord. I of my own cannot make any
No, that we
conclusive
understand,
submissions, my
but
lord.
we are, that is the law, that is the question of law.
Yes.
Facts we are not disputing for the time being. Though they have raised a dispute, saying that no, never it was, we are not even relying on the EO note of the education minister. That will take note of. That will take note of. I think you need to make that person a party in view of their denial. The person who has issued, the education minister, they are not saying that this is not issued by the education minister, but they are saying that on the basis of that, you have never gifted land to them. These are dispute they have raised in the writ petition itself. So we are, for that time being, we are not going to those. They have specifically raised certain questions that no, you have never gifted.
Then I give the proposal, my lord, kindly dispose of on a particular question of law. Let the work which they wanted to complete, let them complete. And the deputy commissioner take a call on the
Definitely.
on
your application.
On my application.
On your application. And also while taking such application, you will take note of the EO notes and all.
Yes, and all those.
All the claims of the petitioner, it's are open. We have not commented anything.
Correct.
We'll say that.
And in that case, if this writ petition
If
is
it is held that petitioner is entitled.
Yes.
And even if in case of rejection, you will have to give a definite reason for rejection of your claim.
Then, that is called that adversary principle will come into, because that on the basis of.
So we can dispose it of the entire matter.
Yeah, with that.
If we want to go to the merit of your claim, then we'll have to defer the main matter and vacate the stay. And if you say that we'll decide relegating the deputy commissioner to decide on the basis of your application for allotment of land.
I just seek a small liberty. I come back tomorrow morning with the instruction of my client.
Okay.
On the desk. Because I cannot take a decision on this.
Okay. On the prayer of the learned counsel for the petitioner, Mr. Titi Tara, matter stands adjourned and be listed tomorrow to obtain instruction whether this matter can be disposed of, relegating the matter to the deputy commissioner for deciding the claim of the petitioner so far relating claim of the petitioner regarding his right of allotment in view of the land he has purportedly given for construction of agricultural horticulture college at Pasighat
in the year 2010.
In the year 2010, which fact is also been admitted by the then education minister. And allow the Pasighat Smart City
Development Corporation
to continue with the
without prejudice
with the work in question without prejudice to the right of the petitioner for claiming compensation or alternative land. Alternative land. Full stop. List accordingly tomorrow.
Great.
You have this, I think.
Yes.
We will not close your chapter, but because of your this, they have taken a stand that all these are not. So we'll not look into this for the time being. Yes, what is this?
My lord, this is also one small bill pending. Matter
Where is the
government was
affidavit?
supposed to file affidavit.
You file affidavit because it's difficult.
My lord, last time they have
The
taken,
present application is filed claiming that the pending bill amounting to rupees 47 lakhs only for work executed by the petitioner has not been paid by the Department of PWD, no, by the PWD Department, Palin Division, Kradadi District, Arunachal Pradesh. The respondent shall file a specific affidavit whether the petitioner has executed the, what is the work order? Whether the petitioner has executed the work in question. What is the work?
my lord, my
What
lord,
you have,
it
huh?
is page number 13, my lord.
Huh?
Page number 13.
Page number
13.
13. Yes, what is the work? TT Enterprise.
TT
For
Enterprise.
the execution of work within inverted comma, special repair and maintenance of roads and bridges, including restoration of flood damages. Full stop. Inverted comma close, full stop. List after
4 weeks, madam.
My lord, last occasion, the respondent authority has taken as the last chance, but
No,
now
that was
same.
in the other case, my lordship, not in this too.
Okay.
My lord, this has been also
Okay, list
filed
this
in the,
matter on.
After.
You have
after
not
4 weeks.
appeared on the last occasion. For non-appears for the petitioner, you are showing urgency. List this
my lord,
matter on.
however, this is it's
Give a
been
date.
very late.
After 4 weeks, any
After
date.
4
huh?
weeks.
Give
Well,
after 4 weeks. By which date the respondent shall invariably file their affidavit.
That's obligement.
You just tell us what is what. If he has work, you pay it. We'll give a specific
Yes, my
time.
lord, it's very
If you are
pity
taking
amount
the
also.
work and not paying and raising dispute in other case, it was a different.
Yes, my lord.
Immediately. Yes, next.
Obligement.
Yes. We'll take the other methods first. We'll decide this.
My pleasure, optional.
Yes.
And on the last two occasions, they took time to file affidavit. Matter released to my lord.
We have received instructions.
Yes.
We'll be filing that.
You have received instruction.
Yes, ma'am.
Okay. You are for? No, you are for which
For
respondent?
the state. madam.
Huh?
For the state.
For the state. Spensor Learned Council for representing the state respondents submits that he will be able to file the affidavit in opposition by within
Well, we need 2 weeks, madam.
within 2 weeks. Okay. Full stop. List accordingly on your next date is
21
21
December.
December 20. Nothing will happen 21st of December. All everybody live in the holiday mood. Yes, 15-16 affidavit file. Then
My lordship, we need some more time to file for affidavit for respondent number 6. my lordship.
respondent number
6.
6, 15 and 17 file.
Yes.
It is submitted by that though affidavit on behalf of respondent number 15 and 17 has been filed, they will require to file an affidavit on behalf of respondent number 6 also. Full stop. Accordingly, see praise for and is granted. How much time?
4 weeks.
4 weeks time to file such affidavit. File such counter affidavit. List accordingly.
21.
Yes, what is this?
My lord, it is a service matter. Here, the affidavit has been already filed by the respondent. And only in which I would like to file
Reply.
rejoinder on that.
And what about respondent number 6?
My lord, that is the one thing that there's two director unnecessarily it has been implemented. So this can be struck out because local urban body has been already even filed the respondent, and it is outbound director.
This
who
is
was
not necessary.
Yes. It's already his
This is by name.
by name. So this can be struck out. It is of no use.
Learned counsel for the petitioner submits that name of the respondent number 6 may be deleted from array of parties as array of parties, full stop. Without accordingly, on the prayer of the learned counsel for the petitioner, the name of respondent number 6 be deleted from the array of parties with the risk and cost of the petitioner.
And
With the not cost, with the risk of the petition.
and meantime, I may be filed.
Full stop. As the respondent number, other respondents have
Yes.
filed their affidavit. The learned counsel for the petitioner prays for and is granted
1 week time to
10
file.
days time to file a reply to the counter affidavit.
Most obliged, my lord.
Yes, counter not filed.
Counter not filed.
Yes. Faith respondents. And what about notice upon 9, 10, 11, 12, 14, 15, 16, 17, 21, 28, and 35?
We have, my lord, we have taken steps, my lord.
But what to do? You have taken steps when? You have taken steps when? And what about 16? 16.
My lord, I'm appearing.
Which respondent are appearing?
I'm appearing for 13 and 19 to 27 and then
19, 27 and
19 to 27. my lord.
19 to
27
19 to 27 represented.
and 30 to 34.
30
to 34.
30
30
to 34. 34
34.
represented.
My lord.
Now, what any other? Who are the others? Yes, you are for
My lord, I am for respondent number 1, my lord.
respondent number 1 is represented. And any other? In only one state respondent.
The education department is there.
Education department.
And for respondent 1, 4,
2, 3, 4.
Not one. One is cut off.
5 is finance.
Tell us the government respondents. Who are the government respondents?
22. I'm for 1, 4, and 5. my lord.
You are for 1, 4, and 5. Now you are for?
Me, my lord.
No.
No,
You are
he's-
for?
He's not there in this case.
I'm sorry, my lord. I was under the impression that item number 19 is taken, my lord.
No.
I'm sorry, my lord.
Okay. So 1, 4, 5, then 6 is not there. 6, 7, 8, and 9.
6, 7, 8, the education department.
6, 2, 6, 7, 8, who?
Education department.
Education, it is gone. Then
Then 3 is also education department.
3.
3.
3 is gone.
2, 3, education department.
2, 3 education department. 2, 3, 9 gone.
Then 4 is 4, 5, and 6, my lord.
Who are 4, 5, and 6?
4, 5. 4 and 5, finance department.
Department of Finance.
Finance, so that is there you are having, you can appear, government can appear,
Yes.
4, 4, 5, 6, then
Then 6, 7, 8, education department.
6, 7, 8 education department. Then which are the private respondents? Tell us.
I'm appearing for private.
No, not all.
Not all.
Who are not appearing? Tell us.
You are appearing on behalf of me.
19 to 27. Up to which respondent, Mr. Pukasta,
My lord,
up to which respondent is there the official respondents? Tell us.
up to, my lord, 8, up to 8.
Who is, so from 9 to 18,
Yes, 9 to 8.
9 to 18. Who appears?
Nobody appear, my lord.
Okay, 9 to 18, then
Then 19 to 22 appear.
just a minute, 19 to 27, then 28, 29, 30, 28, 29. Who appears for 28 and 29?
Nobody.
Nobody. You take first steps.
Regarding 28, 29.
No, not 28, 9 to 18, 28, 29.
On 9 to 18 and 28, 29.
And 35.
My lord.
How many respondents? 35 respondents?
Yes.
Huh?
My lord.
Nobody is having file or what?
35 respondents. Let us respond.
You are not, nobody is having file.
You know, Quran.
And this matter will go on and on like this.
I will clarify, my lord. Private respondent numbers 9, 10, 9, 10, 11, 12, 14, 15, 17, 21, 28, and 35. Service report is elevated.
No, understand.
Hello, 35.
Huh?
Total is
Total 35. So 9 to 18.
Yes, 13 I am appearing.
No.
1, 3, my lord, I am appearing.
13 you are appearing.
Yes, ma'am.
You said 19 to
No,
27.
13 and 19 to 27, and then
And 30 to 34.
34.
These are the private
Yes, yes.
respondents. Then who remains? 9, 10.
11, 12.
No, 9 up to 9 it's a government.
No, but up to 8 is government.
Up to 8 government.
Government.
9, 10, 11, 12, 14, 15,
17,
17, 21, 28,
and 35. Service report
35.
still elevated.
Hmm?
Await service report.
We cannot wait like this. It's steps taken when tell us. On 19/8/23. Okay, await service report in respect of respondent number 9, 10, 11, 12, 14, 15, 17, 21, 28, and 35. And list this matter after 4 weeks. In the meantime, the respondents, other respondents may file their counter.
On 16/8/2023, I had made the submission that respondent numbers 24, 26, 27, and 33 have retired. Therefore, their names may be struck off. There's an observation.
File an application. File an application. If they are retired, they have retired. You are not going to all complications. You are representing them. You are there. Be there. These people might have also retired in the meantime. Have the instruction. Yes. Next.
Please,
Yes,
Lord.
Mr. Kato, what is this?
My lord, subject matter is already pending before this honorable court, my lord. The village authority, my lord, has passed an impugn order by which, my lord, the rights, title and the ownership has been decided in favor of private respondent number 5.
Challenge that.
My lord, difficulty.
What was the main, what was the main?
My lord, I have two LPCs, two notes of LPCs. LPC has been issued in favor of me, my lord. And on complaint of the, my lord, the respondent number 5, private respondent, who was my lord ex-wife, my lord, additional deputy commissioner, my lord, on flimsy ground, my two LPCs has been cancelled.
That you have challenged in this
Yes,
writ
in
petition.
read petition. my
There
lord.
is a stay.
No, my lord. Admittedly, on the returnable date, my lord, the interim period will be considered, my lord. Now, my lord, if my two LPCs are restored back, my lord, titles and ownership over the said land will be, my lord, will be restored to me, my lord. If this honorable court interfere, my lord, the impugn order passed by the ADC,
What is the stand of your respondent, private respondent?
my lord.
There was a caveat.
Yes, my lord.
So therefore, my lord, once the, my lord, my writ petition is decided, my lord, the
It's-
ownership will be restored to me, my lord.
Jamu appeared for the caveator. His name is shown.
Jammu.
My lord, no, there is no
HK
caveat.
Jamu, huh?
No caveat in the, my lord, earlier it was caveat.
No, caveat was there. Any name is shown because
Yes,
there-
yes.
there was no stay.
My lord, while,
So we are issuing a notice today.
my lord, in the meantime, my lord, the impugn order passed by the village authority may be, my lord, in the.
Where is that village authority's order?
My lord, I have enclosed a copy of the, my lord. It is annexure. Impugn order is annexure. My lord, 5, page number 18, my lord.
But village authority's order, you can challenge before the
My lord, specifically, when the matter is already sub judice before this honorable.
no, it's sub judice, but court has, after hearing the caveator, no interim order was
No, my lord,
granted in
only-
your favor. Your LPC is cancelled. That is not stayed.
My lord.
Now, what is this?
Page number 18. So many things has been written. This is the malad which I have impugned in the main writ petition.
You will have to challenge this. How can you stay this without being challenged? You have to file a writ petition.
Malad,
Suppose you stay it for a moment. Where will you say set aside this order? This is basic fundamental.
malad,
Until and unless you pray an order for okay, stay fine.
malad.
Can an injunction be granted without a declaration being sought that this is bad or a permanent injunction?
No, malad, once the very root of the merit of the case, malad, if subject matter is
No,
pending in
no.
the writ
You
petition.
say that since matter is pending before it,
My
they are having no jurisdiction. Keba is not having this village council is not having jurisdiction.
My lord.
So therefore, their whole proceeding is to fall. And therefore, in view of that, we need to stay this. Is not it?
My lord.
Is it not an fresh cause of action? Until and unless you seek a writ of certiorari to set aside this order, can we set aside this order?
Well, since the already subject matter, my lord, as
Already subject matter is what?
my lord,
That
two
your
LPCs, my lord.
LPCs are cancelled. We'll
My lord.
examine that whether LPC is not
Yes, my
cancelled
lord.
or not.
Once the LPC
Now-
is, my lord,
Restored.
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 My lord.
That is one aspect of the matter.
Yes, ma'am.
Other aspect of the matter is that when this matter is pending, you have approached, we very well can understand, but can we stay without there being a primary principal challenge to this?
My lord, this is, my lord, my limited understanding
Suppose
is.
we stay this,
My lord.
no problem on
My
that.
lord.
Now, suppose we restore your LPC, will this order automatically go?
That therefore, my lord, I am praying before this honorable.
Automatically go.
Yes, my lord. My lord, the legality and the propriety of this order will be, my lord, subject to the outcome of the main writ petition, my lord. If the ones, the my lord,
Yes,
LPC,
Mr. What is the procedure for this all these disputed question LPC cancellation? Who will
LPC
decide?
also granting, the authority is the deputy commissioner.
But cancelling is what is the appellate authority?
Appellate
Can
authority-
read court decide all these factual aspects?
The deputy commissioner can recall also.
No, deputy commissioner support records factual disputes.
No.
Okay. Now that factual dispute are agreed by one of the parties. Where will they go? to the read court. There is no appellate provision.
No, my lord.
Appellate provision.
There is no, my lord, as per the, my lord, only guidelines, the LTCs are being issued, my lord. The same authority issued.
No,
the
that we
LTC
understand.
My lord.
You have to advise your client to the state that these are the lacunas you are every day you are experiencing.
Lordship, here,
Suppose say, see, I'm not blaming
Yes.
because it's a transitional form.
My lord.
Suppose there is a LPC is issued.
Lordship.
Somebody files a complaint or for any reason, deputy commissioner is empowered to cancel a LPC issued.
Correct.
We are not doubting this power, but having the power is one thing and exercising the power is something different. What is the procedure to cancel?
The procedure is.
What is the procedure?
Procedure.
Can it be in a system where rule of law is there that no deputy commissioner can issue and cancel? So therefore he can issue at his whims and cancel at his whims. And there is no appellate authority.
The
So
procedure,
therefore it could.
there is no statutory procedure laid down.
So therefore what I am
So-
suggesting is you suggest your client, the state, that these are the lacunas and you are the best person to advise your client state because you are experiencing every day. These are the issues. See, here in a case, there was no stay, no doubt about this. But suppose tomorrow a decision is taken. There may be damages caused already done, suppose in his favor. Now the village council has already decided, if we go by the law, the decision of the village council is to be challenged before another authority.
Yes.
Okay. So read court cannot exercise jurisdiction over that decision. In the meantime, a new cause of action has been arisen.
Yes.
Now suppose we can interfere. Yes, we are not powerless. We can even interfere with a order of a village council directly in case of when it is a case of no notice, in case of when it is without jurisdiction, and when it is against the statute. So these three conditions, until and unless he challenges, that will remain. We'll see, may say tomorrow how already it has been decided on taking evidence. So there is no principal challenge to the order. Whereas in view of the earlier order, he has come. So therefore, the timing staying, it will see.
Lordship, here what happened?
And caveat is also not appearing. Let this matter be listed on Monday. We'll have the caveat heard.
Lordship,
Aye.
here in this case.
Hmm.
In this case, Lordship.
There is no stay. LPC has
Yes,
cancelled.
Here, Lordship, admittedly, this lane was purchased in the name of the private respondent.
Hmm.
There's no dispute on that.
No, my
And
lord.
LPC
We are
was
disputing, my lord.
obtained on record.
Moment you dispute, we are our heights are
This, Lordship.
So you are issuing a notice. He sees your wife,
Ex-wife, my lord.
ex-wife.
Ex-wife.
At the time of good days, you bought in her name.
Exactly.
Now the bad days has
My
started.
lord, so many properties has been bought, my lord.
What do
During-
you do?
And my lord, so many properties has been given to her also, my lord.
Yes, what do you do? Your profession, huh?
Engineer.
Yes, my lord. I'm a junior engineer, my lord.
That is the problem, your problem. That is your problem.
My lord.
You need so many wives and so many properties.
Properties is,
How many wives?
my lord, one.
One.
Yes,
Or and this ex.
yes, my lord.
Ex and present one.
Yes, my lord.
Give something to present one also.
My lord, she's having sufficient, my lord,
Okay,
properties.
we'll consider on this matter. This IA is filed for stay of a decision. Dated 12th of October,
No, my lord, 24 October 2023, my lord.
24th of October 2023, whereby the disputed land in question whereby a decision was taken holding that the respondent number 5 herein is the owner of the disputed land in
My lord.
question. Accordingly, the learned counsel for the petitioner submits that as the entire matter regarding issuance of LPC and cancellation thereof in the name of the petitioner is pending adjudication in the writ proceeding, which is having a direct nexus with the decision of the aforesaid decision dated 24th of October 2023. Decision 2023. Such order is required to be stayed. It is seen from the record that the respondent number 5 in whose favor such order has been passed is being represented by Mr. Jamo, H.K. Jamo. H.K. Jamo. However, his name is not shown in the cause list. First off. Accordingly, the matter stands adjourned and will be listed on Tuesday. Okay. Monday or Tuesday.
Monday, my lord.
Monday, listed on Monday,
My lord.
showing name of Mr. H.K. Jamo as the counsel for the respondent number 5.
I'll inform
Full
also,
stop.
my lord.
List accordingly. We'll see on that day.
Deeply appreciated.
See, you have these two problem, I think so.
My lord.
Yes.
Deeply appreciated.
Yeah, no, basic matter नहीं.
My lord, this is relating to land acquisition matter.
Land?
Land acquisition matter.
No counter has been filed. Why this matter is mentioned?
My lord, the 3 months have already passed. after
So
filing
filed,
application.
yes, madam, 3 months already passed. Now this is, earlier this was not complained in Arunachal, that no affidavit is filed. That was complained in principalship, that affidavits are not being filed for months. Now this time I've seen here also. Yes, when?
4 weeks, my lord.
What 4 weeks? Why you need 4 weeks? Reduce the period.
3 weeks.
3 weeks.
My lord, that may be last chance.
Okay.
Last chance.
But this is 2023 matters anyway. The learned counsel representing the state respondents.
I'm
Raised-
respondent number 5 only.
Respondent number 5 raised that C may be granted some time, granted 3 weeks time to file counter affidavit. Prayer is allowed. List accordingly. Yes, you need to give proof of service in respect of respondent number 4.
My lord, I have already
You have
extra
submitted.
copy also.
Huh?
I have extra copy also. my lord.
Okay. Okay. No need to pass. Respondent number 4.
Respondent number 4 as well as, just a second, my lord. Respondent 2, 3, 1, 2, 3. And 4. Yes, I have some extra copy also. 4 and 5 also.
4 who you have served a copy on 4 also.
My lord, 4 is
Arunachal Pradesh
Yes.
Secretary Land Management.
Secretary Land Management.
Secretary Land Management.
Yes, my lord.
There is standing council, I think, Land Management.
Yes, my lord. Mr. Kamduk.
Okay.
All of you.
Appearing for respondent number 9 and 10.
9 and?
9 and 10.
And what about your affidavit counter?
And I required some time to file.
And about others?
I appear for 4, 5, 6, 7, 8, and 11.
Okay, service is complete.
Service is complete.
The learned counsel for the respondents pray for and is granted
It can come up on the 8th of December, Your Lordship.
Granted, 8th of December will be 2 weeks. 2 weeks
Around
time.
2 weeks, around 2 weeks.
More than 3 weeks, huh?
Yes.
3 weeks time to file affidavit in opposition. To file counter affidavits. Full stop. List accordingly on 8th of December 2023. Have you served them the additional affidavit? You have filed an additional affidavit?
Yes.
Have you served the copies to them?
Given it to them.
Okay. You filed in there also?
All right.
After 27 and 28. Well, I'll go there. After this. This matter is ready as regards service. However, no counter has been filed. Huh? Okay, affidavit filed. This matter is ready as regards. Pleading is complete?
Yes, Lordship, only with regards to respondent number 5. If
5 may not be required.
Okay.
It doesn't matter.
As the matter is ready as regards service, list this matter for admission in the next week.
interim may be continued.
Interim order pass earlier shall continue till the next date of listing. Both same, 27 and 28, isn't it?
No, not same.
Huh?
28 is different.
28 is different.
Okay.
Deeply obliged.
Service is complete.
Complete. Kindly give them, fix it on 24 for disposal. Because this is, I obtained the NOC. And then they have withdrawn it without following the witnessment principle.
24.
24. There is urgency, my lord. Kindly, they are trying to stop me from contesting election, lord.
Can it be on 28, Your Lordship?
No, my lord. There is urgency, my lord. 24. Kindly, my lord. 24.
This
28,
happens.
we'll file, Your Lordship, on 28. Before 28, we'll file.
No, my lord.
It may be listed on 28.
No, my lord. There is urgency, my lord, with or without. Because they are nothing to defend in this case, my lord. Kindly see the ground that I have taken. My synopsis is enough, my lord.
Yes. How can you? He has resigned, he has resigned. You have accepted, they have accepted. What more is required? He is so strong a candidate. He is so strong a would-be candidate.
That's sitting minister I am contesting. 24, Basar, please.
24.
24, my lord.
Okay. We can record it that you are
No, my lord.
intended to.
No, my lord.
Then there will be urgency.
No, my lord.
Okay. The learned counsel for the state respondent prays that she may be granted a week's time to file affidavit, to file counter affidavit. However, Mr. Tara expresses serious urgency in the matter. Inasmuch as it is his submission that the petitioner has duly resigned from his service, which was duly accepted, and thereafter same has been withdrawn, which is not permissible under law.
NOC, instead of resignation.
Not the
resignation. Because of that, they are going to
applied
install
for
my...
NOC, which was duly issued and subsequently has been cancelled without following due procedure of law,
Correct.
which is not permissible.
Permissible. Interim order to continue.
Accordingly, the matter is fixed on 24th. You file by Monday. Let him be
Lordship.
short affidavit. The reason he'll have to say.
Lordship.
File affidavit on or before 24th of
November.
November 2023, and also shall be ready with the record pertaining to the reason of withdrawal of the NOC, which is under chair.
Interim order to continue.
Interim order pass earlier shall continue.
Grateful.
We are having the no objection right now.
Right.
Okay, how many matters are there now? Then we will come back to the other matter. Now, anything or 29 is there? 31, 32 will see. 29, just call the 29. Then we'll come back to that matter. Then we'll go back to that eviction method.
May it please your lordship. Lordship,
Yes.
I'm a cerebral stroke patient, my lord. I was working in SEPA as an accountant in Diet SEPA, my lord, where I suffered the stroke. Thereafter, I was transferred. I had undergone treatment at Dibrugarh because there is no neurologist or neurosurgeon in Arunachal Pradesh. My lord, for that reason, I was transferred to Naharlagun, my lord, Diet Naharlagun by the previous transfer order dated 11/11/22. Now, my lord, the impugned transfer order has been passed, my lord, 25/9/23, my lord, transferring me to Diet Daporijo. But there is, because of the lack of medical facilities there, my lord, because I have to undergo treatment in Dibrugarh, my lord. I have annexed the medical documents. My lord, there was a previous stay order, status quo order, my lord, before transferring the matter to this bench, my lord.
So you continue.
My
My
You
lord,
file an
this is
affidavit?
for the first coming up, first time after transfer, my lord.
You need some time.
My lord, 2 weeks time, and in the meantime, my lord, my friend named Sanity copy.
Yeah, I will today.
The
My
Learned
friend will-
Counsel for the state respondent. Please for
2 weeks time. my lord.
2 weeks' time to file affidavit. Prayer is allowed. The petitioner to take steps for service of notice upon respondent number 7.
I have already, man. In principal seat.
Steps is taken. Though you'll have to
yes,
take a
yes.
steps here.
Yes,
Though
yes, yes, my-
steps, it is submitted that the steps for service of notice upon respondent number 7 has been taken at the principal seat when where the matter was first moved, comma, petitioner need to take fresh steps for service of notice upon the respondent number 2 in terms of the office note dated 15/11/2023. Full stop. Notice is made returnable after 4 weeks. List accordingly. List accordingly.
After 3 weeks, man.
No, notice is.
Okay, my lord,
notice is
my lord,
notice. You'll have
yes,
to be
yes.
4 weeks.
My lord.
Or no, returnable. He's aware.
My lord.
The other party is aware.
No, he's aware.
also not coming. He also might be happy.
My lord, that we cannot say.
Otherwise, so he would have rushed it. He would have rushed to the court with the interfix.
My lord.
4 weeks. List accordingly after 4 weeks. In the meantime, interim order pass earlier shall continue.
My lord, may I pray for a date, my
Okay,
lord?
give a date.
My lord, 19 December, my lord.
19th of December.
My lord. Deeply.
Notice is made returnable on 19th of December. Could you? Yes.
May I make a prayer, my lord?
Yes.
The item number 30 and 31, I have taken the consent, my lord.
Uh,
So these two items I couldn't prepare the case, my lord.
you want to go home?
So, if of
Okay.
your permission, my lord.
On the prayer of Mr.
31 and 32. 31 and
Pastor, 31 and
32.
32.
No matters matter.
10 said Johnson. Other is, what about 30?
30 is, my lord, in respect to, my lord, matter relates to promotion, whether a particular post is a promoted post or not. Government file affidavit.
So
government
that also you can do it on next date is 9. For which date is it suitable?
21.
Huh?
21.
21st.
December.
This 21st of this, nothing will happen. Next from the next day holidays. Here everybody will be in a holiday mood.
Let me try my luck.
Isn't it?
My luck.
That's why you're taking a fixed date on 21st. You have selected this Susan date. Yes. Now we'll come back and hear that other matter. Just give us the brief story of your case.
Your Honor, on the last date, this honorable court had raised the question with regard to the state officers under the act. So I've brought the notification with regard to which the state officers in various districts, like the additional deputy commissioners, have been appointed as the state officers. However, in our case, the district that we are concerned with is Lower Siang district, which initially, and Likhabali is this place, which initially was under West Siang district. And now it has been bifurcated and it is under Lower Siang. So your honor will not find the district under this notification. But if you look at the impugned notices itself at page number 24, the notice dated 17th April 2020.
These are the state officer. Notices
These are the
issued by the
state
ESC, not by the ADC.
Yes, Your Honor. No. So the notice had been issued by the EAC. However, the order of eviction that was passed by the deputy commissioner. So that is where the jurisdiction error comes.
Lordship, the DC is the affiliate authority. So he cannot act as an
So we'll set aside it. Since already you have evicted her, she claims a right over the property. You better file a
Civil suit.
civil suit. Because this authority cannot decide. You file a civil suit. However, we'll set aside this, and this decision we shall not either way affect the rights and contents of the parties before the civil suit.
Yes.
They can also take their stand, you can also take this, but only on the jurisdictional error we are setting it aside.
Yes.
You have your get
Yes.
it, get a decree.
Yes.
We never thought that it will end like this. He has got this, so this is the issue, jurisdictional issue.
Otherwise land
Belongs to you.
Yes.
No, that is not this, that is disputed. That is why it needs to go.
So
before
we
the-
cannot determine that.
My lord.
Neither we can decide it, nor the authority can decide it.
Yes.
Because it's basically a prima facie satisfaction, this is a government land.
My lord.
Is that it? If she can prove, and she can even have an adverse right of adverse position, but that periods are there, so therefore all is to be determined before the civil suit. So we'll say that we are not commenting on merit of the. Yes. Where is the act? This is that. Where is the provision of notice?
Section 4 and Section 5.
Huh?
Section 4 and Section 5.
volume 8.
Section 4 specifically for notice. And 5 is for hearing.
This action was done in the year.
Eviction was done on 21st of June 2023.
23.
And you know, also with regard to the same issue,
Any notification subsequent to this?
I am not aware of that one.
No, Lordship, I had that formal talk with the DC also. He said that since there is no ADC, ADC usually they act as a de facto that one.
State officer.
State officer, but there is no ADC
In
Lower Siang district.
It's newly created district.
Newly created district.
So no ADC, therefore given by ESC.
ESC, Lordship, for ESC also it has to be delegated by the state government again.
Okay, state government is delegate, so there is no state officer.
No state officer.
So no state officer. So if no state officer, no validity of the notice, and assuming that the eviction order has been issued by the deputy commissioner himself, which is an otherwise an appellate authority, isn't it? What is the provision of appeal?
Appeal, Lordship, is
Section
at
12.
section 12.
Huh?
Section 12. 12 is deputy commissioner.
And
Shall be made to the deputy.
Section 12.
12.
12.
Heard MS Bhutia,
T.Y. Bhutia.
T.Y. Bhutia.
Also, Your Honor, I'm relying on this judgment that was passed by Justice H.N. Sharma or that of this honorable court, wherein similar matter was decided and then the order was quashed.
Uh, 12, na? Section 12.
When you
Okay. The present repetition is filed assailing notices dated 17/4/2023, 19/5/2023, and 31/5/2023. Where is that? Where are those?
And at page 24, 25,
Is
24, 25, 26.
Notice dated notice dated come on. Spencer. Where is the eviction?
Page 26.
Eviction order is at page 26. Final order for eviction.
Where is that they have said that this is under the act?
At page number 25, Your Honor. Second paragraph, it is written, you are hereby reminded to vacate the land of Medical Department Likhavali within a period of 7 days of this notice, failing which legal action shall be initiated by the OCPS Likhavali as per appropriate section of law under the Arunachal Pradesh Public Premises Act
Okay.
2000.
Okay. Challenge notice purportedly issued under provision of Arunachal Pradesh Public Premises Act 2003. Where is your reply?
Reply is at page
The
49.
further challenge is an order dated 31 May 2023, whereby the Deputy Commissioner issued the order of eviction order of eviction dated 31st of May 2023. And according to the petitioner, on the basis of such eviction order dated 31st May 2023, impugned in the present petition, the petitioner has been evicted from his house and land.
The house has also been demolished.
Land, and the house has already been demolished. Full stop. The basic case of the petitioner is that the first notice dated 17 April was issued by one EAC on behalf of Deputy Commissioner, and subsequent notice dated 19th of May 2023 was itself issued by Deputy Commissioner, was issued by the Deputy Commissioner himself, and the order of eviction dated 31st of May 2023 was also issued by the Deputy Commissioner himself, which is not permitted under the Arunachal Pradesh Public Premises Act 2003. Inasmuch as from the notice dated 19th of May 2023, it is clear that entire action has been taken on the basis of Arunachal Pradesh Public Premises Act 2003. Full stop. 2003, full stop. The referring to section 3 of the Arunachal Pradesh, referring to the Act 2003, MST Bhutia Learned Counsel contends that only an estate referring to the section 3 and section 4(1), section 4(1) of the Act 2003. It is contended by MS Bhutia that only an state officer is empowered to issue a notice, and deputy commissioner is the appellate authority under section 12 of the said Act /2003. Therefore, the entire action is without jurisdiction and therefore liable to be set aside. Full stop. It is the further case urged by MS Bhutia that in view of the eviction notice issued and action taken pursuant to such notice, this entitles the deputy commissioner to entertain an appeal and makes the petitioner remediless inasmuch as the deputy commissioner, under section 12 of the Act 2003 himself is the appellate authority. That being the position, she having no alternative efficacious remedy, she had to approach this court by filing this petition under Article 226. She further contends that even if assuming that the deputy commissioner is having any power, the mandate to be followed under section 4(1) has not been followed, and the notice does not reflect any reason to evict the petitioner, inasmuch as the procedure required to be followed under section 5(1) to consider the claim of the petitioner has not been complied with, inasmuch as the petitioner has filed his objection on
24th April 2023.
On
24th April.
24th
2023.
April 2023, and the eviction order does not reflect any finding of such, any finding that is required to be taken, recorded under section 5, subsection 1, under section 5 within bracket 1 of the Act 2003. Yes, what is your argument? This is the matter of law. The learned state councils fairly and candidly submits that in terms of the section 3 of the Act, the state of Arunachal Pradesh has already notified state officers in the rank of additional deputy commissioners. However, in the case in hand, as there was no additional deputy commissioner, therefore, in a compelling circumstances, the EAC issued the notice. However, they concede that the deputy commissioner in the scheme of the Act shall have no power either to issue notice or to direct issue an eviction officer in exercise of power under state of in exercise of power as an state officer, and inasmuch as deputy commissioner is the appellate authority under section 12. Full stop. MS Bhutia, learned counsel, in support of his contention, relies on the decision of this court rendered in 2006. What is this?
Tatar Mite,
What is the volume?
2003, 2006 GLT.
No, there must be some. Yeah.
2006 GLT 280. Citation.
We will not rely on, we will allow this petition because there is no citation is 2006, no GLT number is not there. Maybe 1, maybe 2, maybe 3.
Oh, yes,
We cannot give a wrong citation because this is from case mine.
yes.
Okay. So there must be some.
It is in the supplementary volume. Even in this case, Your Honor, similarly, Deputy Commissioner had delegated his power to the EAC. However, he himself had passed the eviction order.
Okay, we'll quote this from this judgment only. Our decision also is similar to these judgments only, okay?
Yes.
Section 3. 1 mandates that state officer is to be appointed for the purpose of the Act 2003 by notification in official gazette. Full stop. In the case in hand, an official gazette of 29th of April 2003 issued in exercise of powers under Section 3 is produced, which reflects appointment of additional deputy commissioners of as many as 20 districts as state officer. However, pursuant to such notification, the present district in question was bifurcated into 2 districts, namely
East Siang district and
East Siang district and
West Siang.
West Siang, East Siang district and West Siang district,
Lower Siang.
Lower Siang district, East Siang district and Lower Siang district.
It was
West Siang and
bifurcated
Lower-
from East Siang and
West Siang.
West Siang district.
No,
It was bifurcated
But
from
it was carved out from
It was
both
the
East
present
Siang and
present
West Siang.
district, namely
Lower Siang
Lower
district.
Lower
Siang.
Siang district.
Lower Siang district
Carved out
was
from
carved out from
2 district, my lord.
2 districts, namely
West Siang district.
West
and
Siang district
East
and,
Siang district.
and East Siang district. Full stop. The notification shows that the additional deputy commissioner East Siang district and additional deputy commissioner Upper Siang district are notified in the aforesaid gazette dated 29th of April 2003 as the state officer under the act. Full stop.
West Siang, West Siang.
Huh?
West Siang.
No, here it is written Upper Siang district.
Lord
Upper
saying
Siang
West Siang.
and West Siang is notified.
Huh?
Upper Siang and West Siang is notified. Lower Siang is not notified.
Your is Lower Siang.
Ours is Lower Siang.
However, when these districts were created,
My lord, sometime in
13 or 14.
but how can then Upper Siang district will come?
No,
in
no,
here?
Lordship. East Siang is there, Lordship.
Lower Siang it is recently carved out, created. That is why, my lord. That was part of East Siang, my lord.
And Upper Siang.
No, lower West Siang.
West Siang is no more. Okay, West
Siang.
East West Siang and East Siang.
Yes, my lord.
So কি লিখিলে আপনি? West Siang district and East Siang districts were notified as the state officer by the aforesaid notification dated 29th of April 2003. It is submitted by the learned State Council that in view of a creation of new districts, no notification has been issued so far relating to the Lower Siang district, which is carved out from the Upper Siang district for West Siang district and East Siang district. From West Siang district and East Siang district. From the aforesaid, it is clear that no state officer has been appointed. So far, the same relates to Lower Siang district as required under section 3 of the 3 within bracket 1 of the Act 2003. That being the position, neither the ESC who issued the notice, first notice dated so and so, and the Deputy Commissioner who issued the second and final notice to the petitioner in exercise of power under the under the Act 2003 was not authorized person to issue such notice under the scheme of the Act, they being not appointed as an state officer under the Act, inasmuch as Section 4.1 specifically mandates, Section 4.1 specifically makes, Section 4.1 of the Act 2003 specifically mandates that notice is to be issued by the state officer. That being the further Section 12 designates the Deputy Commissioner. 12.1 Section 12.1 designates Deputy Commissioner as an appellate authority to take appeal from every order of the state officer made in respect of any public premises under Section 5 or Section 7 or Section 8 or Section 10. Full stop. That being the position, this the learned counsel for the petitioner is correct in arguing that she has been made remediless of seeking even a proper appeal. Full stop. Further, Section 5.1 of the Act also lays down certain procedure which includes lays down that the state officer must satisfy that the person whom they are seeking to evict is an unauthorized occupant over the alleged property. Unoccupied or unauthorized occupant over a government land / property. Okay. However, the order do not disclose any such satisfaction arrived at by the state officer, by the deputy commissioner, while issuing the impugned order of eviction dated.
Final order.
There, that last order.
31st May 2023.
Huh?
31st May.
31st May 2023. Inasmuch as there is not even a reflection or whisper as regards the allegation raised by the petitioner. First of all, that being the position, this court is of the view that the entire proceeding initiated against the petitioner as well as the eviction executed is without any sanction and authority under law and without jurisdiction. And that being the position, the same is set aside and quashed. However, it is on record that in the meantime, after the eviction, the Department of Health has continued with a construction of a hospital.
Yes.
Hospital over the plot of land, over the disputed plot of land, which the petitioner claims to be the owner, and the construction is going on. In that view of the matter, restoration of possession is not possible to be directed by this court, inasmuch as in the event it is held that petitioner is the owner of the aforesaid land, she can be very well compensated either under land acquisition, compensated inasmuch as a person cannot be evicted from a land without following due process of law, more particularly the Land Acquisition Act. Therefore, as prayed for the learned counsel for the petitioner is given a liberty to approach the appropriate forum for declaration of her right, title, and ownership over the property and seek compensation. Full stop. While parting with the record and setting aside the impugned notice dated so and so and eviction dated so and so, it is made clear that in the event the petitioner approaches the appropriate forum for seeking remedy as discussed here in above, observation made in this proceeding shall not be considered as any comment on merit of the title of the petitioner as well as claim of the respondent state. Full stop. Accordingly, with the aforesaid observation, the writ petition stands allowed.
Yes, Your Honor, until then, the construction may be stayed.
No, see, that's why.
Yes, until they approach the lower court, because injunction has to be provided from the lower court.
No, even the lower court cannot injunct to stop construction. That is where my problem is. See, there are even judgments where said prima facie case, balance of convenience, irreparable loss and injury. This, along with this three, when it is relates to state, another goal is the same three golden principles. Fourth is the public interest. So suppose we stop this project, injunction, or the trial court gives an injunction, assuming for a moment. Now hospital is stalled for 10 years. Moment we give an injunction, trial court will also give you an injunction. The hospital is stalled. After 5 years, suppose your suit is dismissed. Now who will compensate this hospital? On the other hand, if the hospital is continued and established, and if your suit is decreed, you can be compensated. We have provided that. So there is no irreparable loss as such.
Yes, Your Honor. However, on the first day, we got our interim stay. And despite that, initially there were no construction going on. But after we got the stay, they started their
Even if
construction.
interim order is there, then also I am even against such kind of interim order because you can be compensated.
My lord.
In a rare case, yes, of course, absolutely you have a clear title. Here your title is not clear.
Yes.
We are not commenting on that. Your title is not clear. If you have an absolute clear title without acquisition, you have been sought to be evicted, then of course we'll grant a stay. But it is not that kind of case that yes, you cannot do it. It is an absolute lawlessness. It's not like that. Admittedly, your father was a employee under the health department. Admittedly, you stayed near the property of the hospital. Now they say that the place where you stayed as an employee also belongs to the state. You say no, but you have no other document to show that this is your Yes, they have committed serious mistake by evicting you without following. So therefore you have set aside. But that technicality is not will give you a right to claim a title. That will depend upon how you prove it in. This may be a futile exercise at the end of the day.
Yes.
Okay, we'll get this order tomorrow only. Where is that? Petition is there? Yes. Kamduk, who is for SC land? He was here only.
And he was there, my lord.
Have you informed him?
My lord, yes. We have given a copy also. My lord, this is my lord. Actually, the petitioner, he's born and brought up in the Itanagar Ganga village, my lord. He's the native village, my lord. He's the one, the father is the one who donated even this capital establishment. My lord will see, my lord, this is regarding where the Geology Survey of India, my lord. They have established and without allotment, without acquiring the land, due process of law, my lord. And formally they were allotted in the year 2020, and that too without affording any opportunity, without following due process. My lord, I'll just straight away, my lord, I'll take to my lord page 47 and 48, my lord. Page 47, my lord, this is by this, my lord, order at type copy as page 48, my lord. This is the formal allotment order given to the Geology Survey of India by the government of Arunachal Pradesh, my lord. Total area allotted, my lord, this approval by the government is 59,742, my lord. Now this was communicated to the Deputy Commissioner for allotment, my lord. Now the my lord see at page 40.
This is the allotment in the name of Land of Geological Survey.
Yes.
Of India. Okay.
Formal approval given.
59,742.
Yes.
Then-
Now this was communicated to the Deputy Commissioner, conveying the approval of the government. Now Deputy Commissioner, my lord, there have my lord, next page, my lord, you see. Now the government approval is 59. Now Deputy Commissioner page 49.
To
page 49, my lord.
Okay.
The allotment, he has given allotment of 82,661, my lord.
Yes.
Now thereafter, my lord, you see, that is access to, my lord, in this regard, my lord, there was a series of objection from the native of the Ganga village. At page, my lord, you'll see page 50 and type copy as page 52, my lord. Joint verification comprising of various officers, they were there, my lord, conducted. My lord, I'll just read status for my lord. With regard to the subject cited above, it is to inform you that the physical verification of GSI campus was carried out on 28 February 2023 by the team comprising of CO Itanagar, RFO, Poma, Wildlife Range, SI authorities, SK concerned area, GPC Ganga. After spot verification, team arrived at the following decision, my lord. First, my lord.
Where ready?
Page 52, my lord, is type copy, my lord.
52. Okay.
Yes.
Okay.
This because of access allotment.
Further is pertinent. Where do you get?
My lord, just their respected sermon thereafter, my lord. With regard to the subject cited above, my lord.
Okay.
It is to inform you that physical verification of GSI campus was carried out on 28 February 2023 by team comprising of CO Itanagar, RFO, Poma, Wildlife Range, GSI authorities, SK of area concerned, GPC Ganga. After spot verification, team arrived the following decision, my lord. Number one, my lord. Survey to be done to confirm if GSA falls within reserve forest, public wildlife sanctuary or not. My lord, status report as on 21 March 2000, my lord, will see. Report received, enclosed herewith. As per the report, to 8,632 square meter area comes under notified area of Ganga Blaze, which is excluded from the Itanagar Wildlife Sanctuary, and remaining 74,029 square meter falls under Itanagar Wildlife Sanctuary. My lord, our land, my lord, my land, 8,000, my lord, this area, this has never been acquired by. Illegally, Deputy Commissioner has allotted to this GSI without following due process, my lord.
Now, what is your grievance?
Now thereafter, my lord, thereafter what happened, despite of these fact, my lord, the eviction, the so-called notice was issued by the state officer on 29/5/2023, my lord, against directing the petitioner to appear, my lord, before the state officer and submit the reply, my lord, written reply. Accordingly, we have submitted the reply, my lord, as page 54, my lord, on 8th June 2023.
Now, where is the decision? 31.
Now, my lord, decision is at page 62, my lord.
3110.
Yes, my lord, 3110, my lord. Now, this decision, my lord, our contention has not been taken into account, my lord. Now, against this, my lord, they have, by this order, they have directed the petitioner to remove, my lord.
Why have you not filed an appeal against?
My lord, I have filed the appeal, my lord. Appeal, my lord, you see at page 66, my lord.
Now,
Page
it's
66.
pending.
Yes, my lord. Page 66, my lord. There, my lord, you see at page.
Where is the
60
order in appeal?
Order in appeal is, my lord, order appeal is.
The learned counsel for the petitioner. The present order is present petition is filed, also heard so and so, so and so. Though name of the standing council, land management is shown. However, none appears for the standing council. First of the present petition is filed assailing an order dated 9/11/2023 passed by
Deputy
the
Commissioner.
Deputy Commissioner and appellate authority, whereby the order appellate authority under the Arunachal Pradesh so and so Act, in short Act 2003. Passed in appeal number 9 of 2023 by the appellate authority under so and so Act, upholding the order of eviction dated
31/10/2020. 31/10/2020.
31/10/2023. 23. Full stop. The order dated 31/10/2023.
Yes, ma'am. 31/10/2023.
31/10/2023 is also under challenge in the present petition. The basic case of the petitioner is that though the petitioners are sought to be evicted on the ground that they are unauthorizedly occupying land belonging to Geological Survey of India, Government of Arunachal Pradesh, Itanagar, Papumpare district. However, the annexer allotment letter is annexer. Allotment letter annexer 4 dated 7th of February 2020 clearly shows that the Geological Survey of India was allotted a land measuring 59,742 square feet, whereas on the basis of such allotment by the director cum ex officio joint secretary, land management department, the deputy commissioner on its own has allotted a land measuring 82,661 square meter on his own. And this is the portion of land which belongs to the petitioner. And therefore, the land allotment, have you challenged this land?
Yes, I've challenged it, my lord.
Such land allotment order is having no sanctity under law issued by the deputy commissioner, inasmuch as the competent authority in the state has only decided to settle 59,742 square meter of land. This matter needs further consideration. Accordingly, issue notice returnable after 4 weeks. So and so, you are Mr. accepts notice on behalf of the
Two
respondent
entry.
number
two entry.
2 and 3. Full stop. A petitioner to take steps for take steps upon respondent number 4.
5, my lord. I'll
5. You are for 2 and 3. What about 1 and 5? 1?
They come to, my lord.
Huh?
Come to standing councils.
1
We
and
have
5. Both.
1 and 2, my lord. Standing council. We have
1
first.
and 2. You are for?
3 and 4.
3 and 4.
You are for 3 and 4. So 1 and
5, I'll take.
1 and 2 be steps upon respondent number 1 and 2 be taken through the office of Learned Standing Council, Land Management Department. First of petitioner to take steps steps for service of issuance of notice upon respondent number 5 by registered post with AD. Full stop. Till such routine of return of notice status quo as on today, so far relating to the land in question be maintained. Full stop. Please record down.
Deeply obliged.
If you have challenged that order, Deputy Commissioners, it's then only we
No,
can-
I'll challenge it. my lord. That's